hit that now.
Okay. Hello, I'm Leslie C. Wester, and I serve as chairperson for the Kansas Behavioral Sciences Regulatory Board. I ask the members of the board to respond with a roll call to signify their presence at this open meeting that is being conducted remotely by conference call and other electronic medium. David Anderson.
Present.
Donna Horner-Queel.
Present.
Jacqueline Lightcap.
Here.
Jonna Norton.
Here.
Bruce Nystrom.
Here.
Andrea Perdomo Morales.
Here.
Laura Shaughnessy.
Here.
Rick Steele.
Here.
Deb Stidham.
Here.
And Carolyn Zasprin.
Here. Here.
Welcome. I note the following staff members are also present: David Fye, Leslie
Here.
Allen,
Here.
Cindy Diocoli.
And I don't believe Cindy's going to be on this call.
I don't see her. And then I see Jane Weiler and Ashley Van Buskirk. Did I get everyone?
Yeah. Ashley maybe join us during the meeting if we need administrative assistance. So,
Okay. All right. Assistant Attorney General Lainey Bernard and Jane Weiler are also present. So I don't see Lainey either. So sorry,
Okay.
my script is a little off.
This is Jane, and Lainey will not be attending the meeting today.
Okay, thank you, Jane. Next, David Fye will read a message concerning this meeting being held remotely.
This is David Fye, Executive Director for the Behavioral Sciences Regulatory Board. Public comment allows the public to address the board about its concerns, but the Kansas Open Meeting Act, or KOMA, does not require the board to provide public comment or answer questions from individuals. Individuals requesting to provide public comment could contact the executive director prior to the meeting by sending an email to david.fye@ks.gov. There will be no public comment at the meeting today, as no individuals requested to provide public comment. Because we're conducting the meeting remotely by conference call and other teleconference ability, I state for the record the following information. Access to this meeting is being conducted by a medium of interactive communication that allows members of the public without cost to attend the meeting through the use of a conference call number and on the board's YouTube channel. While the meeting is conducted remotely, the requirements of KOMA are not suspended. As such, we will be conducting this meeting pursuant to KOMA. On September 29th, 2021, we sent notice of the board meeting to all individuals who have requested notice of the board meetings. The notice was also posted on the board's website, ksbsrb.ks.gov. You may obtain a copy of the notice at that website. An agenda and other meeting materials was posted on the board's website on the day of the meeting, and it has been posted to the website. You may also request a copy of the agenda by sending an email to david.fye@ks.gov with the subject line "request for the agenda," and it will be sent to you. The notice contains information for the conference call and YouTube channel that allows the public to attend the meeting free of charge. The notice also states that if there are any technical issues during the meeting, you may send an email to bsrb@ks.gov. A recording of the meeting will be available on the BSRB YouTube channel following the conclusion of the meeting by using the link to the meeting on the agenda, or you can also go to the board's website and you can find the direct link to the YouTube channel from that as well.
The meeting is now called to order and the board will begin its discussion of the first item on its agenda. But before that, I just want to welcome you all to the second day of the board retreat. It feels like retreat, right? And it's our annual board planning meeting. So we will look at the agenda for agenda approval. If we can have a motion on that, please.
I so move.
Thank you, Donna.
A second.
Thanks, Laura. All in favor, say aye.
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 Any opposed? Same sign. All right, we'll get started. The first thing is new business, and there looks like there's some appointees for the Addiction Counselor Advisory Committee and Professional Counselor Advisory Committee. So I'm just going to move forward with that and appoint Chad Jacobs, LAC from Derby, and Charity, I'm hoping I'm saying her name right, Cawson, LMAC from Sedan, and that's for the Addiction Counselor Advisory Committee. And the Professional Counselor Advisory Committee, Jessica Allison, Harriet Bachner, Michelle Fairbank, and Edel Torres Rivera. So those will all be appointed. Okay. All right, moving on to our annual planning discussion topics, creating guidelines for public attendees of board and advisory committee meetings. So I think, Dave, if you want to go ahead, David Fye.
Thank you. So yes, this is something I wanted to bring to the board's attention and just kind of add as a discussion topic. So as you know, we have board meetings, we have advisory committee meetings, and there is a way for individuals to request time for public comment at those meetings. In the past, public comment presenters have been somewhat rare, usually a handful of individuals per year asked to provide public comment. But recently, last week, we had some individuals request to provide public comment, and there was some confusion. And so we thought going forward, it might be helpful to basically design a handout that we could post on the BSRB website, and something that would be instructional for individuals attending meetings, especially if we're doing them now remotely. Some different things such as Zoom etiquette and making sure that your name is correct on your screen, and also things like what topics would be appropriate for certain committees or the board to hear or discuss, or what other information that's very valuable information we might want to receive in a different way. For example, the board receives information against licensees and other practitioners, sometimes in the forms of complaint or report of alleged violation. But if there is a potential complaint or potentially an active investigation, we'd want to make sure that those are handled consistently like any other complaints or report of alleged violations. And that's why we have an investigator, and we have a formal policy for our complaint review committee. So we want to make sure that members of the public who want to bring important information to the board know the best way to do that. And so in your packet, I did include a document. It's titled House Appropriation Rules for Conferees. And I guess in thinking forward and trying to help members of the public have more clarity on what information may be appropriate for advisory committee meetings or board meetings, or maybe something that should be submitted in writing in the form of a complaint. I thought I wanted to bring this to the attention of the board, and to say I intend to work on something going forward that we can bring back to the board so you can review. But as sort of a starting point, the legislature, for a lot of their committees, at one of their first meetings, they adopt rules for members and also for conferees. And it's more guidelines for conferees, but it sort of talks about the formal process of how the meeting will take place, how they will be referred to, and what's germane in terms of the topics of information and more of the processes. And so I'm not saying that everything on this document is something that we should incorporate for usage, but with more visibility and honestly, we really do want people from the public to be able to approach the advisory committees or the board with any kind of concerns and possible changes to regulations and statutes. We just need to make sure that those individuals who have any information for our agency do it in the right way. So I just wanted to bring this to your attention, let you know this is something that we'll be working on, because we want to make sure that everybody's on the same page in terms of what information we receive and how we make sure that we do things consistently, and also hear from members of the public. And so I wanted to give this to you, and for the next board meeting, maybe on November 8th, I'll have something a little more in line with the way that the BSRB operates in the advisory committees, something a little bit more specific to the agency. But I wanted to catch you all up to speed on the conversation and the need, why I think we need something like this, and then kind of let you know a starting point that I'll be working from. But to give you the opportunity, if any of you wanted to provide some additional comment or any feedback on this. As I mentioned, in previous years, there's been a handful of members of the public who attend the meetings, provide public comment, but in no way would I ever want to, dissuade people from coming to talk to us, as long as it's something that is in the appropriate format and the right forum. So, I just wanted to bring this topic and this item to your attention.
So anyone can provide feedback to you then, David, prior to the next board meeting, correct?
Yes, so what I'd recommend, so to avoid any issues with open meetings, if you do have thoughts on something that would be a good reference for members of the public in terms of our meetings, go ahead and send a direct message to me. And then I'll take all those comments and other information and bring it back to you at the next formal board meeting. And I'll also work with our legal counsel too, because we work with our legal counsel from the Attorney General's office, and they're very valuable to us. And they're very helpful in terms of helping us make sure that we deal with the information consistently. So yeah, if you do have thoughts on this topic, as it would relate to the board or advisory committee meetings, send a direct message to me, and then I'll collect that, and then I'll bring something back a little more concrete to look at for the next board meeting.
Thank you. All right, we need to continue discussion on continuing education requirements in the diversity, equity, and inclusion area. I believe there was one advisory committee that had some recommendations.
Yeah, at the last meeting, so the first half of the annual planning meeting on September 27th, the advisory committees were asked to go back and see if they had specific proposals in this area, and then to bring those back for the board's consideration if they felt comfortable moving forward, or how that would take place. And so some of the advisory committees have had discussion on this topic, and that's kind of where we're at today.
Does anyone have any comments from their advisory committee? Go ahead, David.
Yeah, I would just say our group was not specifically in favor of a requirement for this, but wondered about a broader requirement for hours encompassing special populations, that this could certainly be one of, but might include a broader group of specific populations in which it made sense for those folks to be receiving training in, whether that be veterans or agricultural related communities, so that there was kind of an emphasis on people getting trained in areas that they needed to demonstrate some competency in, but not limiting it to a particular more narrowly defined group.
Okay, thank you. Go ahead, Rick.
Yeah, the Psychology Advisory Committee met again. You'll recall that we made a recommendation in April for DEI training. I directed or asked my committee to take a look at the last meeting where this was discussed, and they did. They have 4 points that they would like me to make. The first is that DEI training, ongoing CE training, is consistent with training requirements for many professions, and that my committee doesn't see it as any different than our current requirements for ethics CE training. Their point is that if all doctoral or most of our professional organizations require ethics training in our training, and we all require ethics training ongoing as professionals, my committee doesn't see why that would be different in this situation. They asked me to note that between 7 and 10 states currently require DEI training for psychologists. This includes Texas, Maryland, California, Minnesota, Indiana, Nevada, Oregon, and there's a handful of others that are considering legislation right now that require anywhere between 2 and 6 hours of CE per renewal period. Texas, oddly enough, is on the high end of that with 6 hours of DEI training per 2-year renewal period. They asked me to point out that DEI training is consistent with both the APA and the NASW ethics standards. Specifically, they noted that the NASW, the new 2021 ethics guidelines, specifically note lifelong and ongoing learning related to cultural humility and diversity issues for social workers. The APA is similar in that regard. And they asked me to point out that this was consistent with an earlier KPA request from November of last year for DEI training.
Andrea, do you want to speak to the social work committee? Because we met just last week.
Go ahead, Carolyn.
Well, I was going to say, I think that the committee feeling that there would be no need to have additional training in this limited topic, but more that they feel like all of that is included under regular ethics training. And certainly, I think that schools and programs should really be the main source. I'm thinking in training, and I think that does happen. So that I think our committee were not in favor, voted not in favor. I did check with our National Social Work Regulatory Board. There are only 2 states, presently, one Missouri, that have any kind of requirement at this point. That doesn't mean that that won't add, but right now. So our committee voted no. Andrea, you can add. That was just.
I think that is correct, that the committee, the majority voted no to include it, but we are going to be asking the question in a survey that will go out to all the social work licensees. So would be interested to see what the input is of the greater licensees on that specific topic.
And I think that'll be very useful for any future reconsiderations or examining of this issue.
Or are we prepared to make a decision today, or do we need to move that to next board meeting? I'm trying to kind of gauge what I know we haven't heard from the other committees. From what I understand, they also were on board with the same, that there should not be this requirement. So if I'm incorrect, you can speak up to that.
Just to recap, the Addiction Advisory Committee was kind of split on it, but all agreed that if it was the will of the other disciplines to adopt something, that they wouldn't have a lot of heartburn about that. So trying in the interest of consistency, we'll adopt what the will of everyone else is. I guess just hearing this topic twice, I don't know that we have, unanimous agreement about it. So it may just be that each discipline will have to pursue their own.
Rick, do you have any comments about that?
I think everyone knows how I feel about it. I think it's ridiculous that we would assume that whatever training we got in school continues to be valid or useful. I don't understand the difference between why we think we have to have continuing ethics education. I mean, we all had ethics training in grad school or wherever, right? But we require that every 2 years. So the idea that we had a class in our PhD program or our social work program that's going to last us forever, to me sounds a little ridiculous. And so I'm disappointed. And we will be pursuing our own if the board won't block that for psychology. I don't understand the rationale. And if one class is sufficient, then why don't we eliminate the ethics requirement for all of us? I mean, I had an ethics class 25 years ago. Surely that's good enough, right? Because frankly, our understanding of the role of cultural diversity has changed more in the last 25 years than any of our ethics, right? So whatever I learned in 1992 about ethics is probably more or less accurate. I wonder if what I learned in 1993 about diversity is still accurate.
Okay, thank you for those comments, Rick. Anyone else have any additional comments?
Just on my own, I'm not against DEI training and awareness. I think it's probably a good idea. But could someone speak to how this fits with our goal or purpose, which is protection of the public? How does DEI training further protection for the public?
I'd be happy to answer that one. I think people who are culturally incompetent may do more harm to their clients than good. I could elaborate. And for example, I know a psychologist trainee who was unaware of some cultural differences in a hospital setting and was asking the child client to do the house tree person, not recognizing that there were some cultural issues with this particular family who happened to be Muslim about drawing family members, right? Creating images. And so that trainee got into a little bit of difficulty with a particular family. Now, fortunately, the person was a trainee and got some good instruction thereafter. But the harm that they did in that moment was real to that family that they were trying to serve.
Thank you.
I have one question too. Has there been any complaints? I mean, has there been an increased number of complaints submitted to jurisdictions or boards against licenses of all professions who have violated, who have discriminated against themselves when receiving services? And I think that's something that we might, it's just the question I have. Yeah, I would think that we'd be seeing a lot or have been seeing a lot. Just a question to consider. Are we getting any kind of review complaints?
Well, and
So I would think that we would.
yeah, so Cindy Arkle, the lead investigator for the BSRB, just entered the meeting, but I don't want to throw her on the hot seat immediately coming in.
Yeah, I know.
I can tell you, I don't believe this is something that we have kept track of in the past in terms of our performance measures. I know Cindy sometimes does look in other jurisdictions for information. So if she's aware of something, she can definitely offer it up. I personally, from what I have seen, it's just not an area that I have seen a lot of statistics in. So I'm not sure that I could speak to that.
I apologize for being late. I had another meeting that I got out late from. And I'm sorry, Carla, what is the question about compliance?
I was just wondering, just a general question, has there been complaint against licensed professionals regarding the inclusion, diversity, or equity? I mean, those three specific areas, umbrella under ethics. I have their clients.
Okay, that has a very specific meaning. I would say our statutes and regulations have an unprofessional conduct. There is a violation for discrimination. And so we do get allegations for people about discrimination and that people were treated unfairly. And so we do get that allegation often. I know that's not exactly your question, but we have to investigate it to see what people mean by that. But we do often have allegations that people were treated, that were discriminated against. And that is often for their, for various, for who they are, and for where they come from. And I know that's a very generic meaning. And that for it could be because they were a foster parent. It could be they were discriminated against for diversity. But we do get that complaint. It could be because they're because they're a male.
I think we're talking two different things, because what I understood from Rick was it's unintentional. I think it's just that some people are uneducated or, not trained well in certain areas that they're conducting business, and I don't think it's intended that they're meaning to harm that person. And from what I'm hearing with Cindy, it's discrimination. So that's
That's just the
whole different
allegation.
right.
That's
That
the
takes a whole
complaint.
different meaning to me.
Yeah,
So.
that's just what their complaint is.
Right.
These could be from people then too that might be professionals that could be uneducated or not trained well enough,
Right. Yeah.
Which is exactly the reason for
Mhm.
this recommendation.
Mhm.
It's good that the CER, the committee has a, can spot those violations and that there can be sanctions regarding that broad area of discrimination. Because as we know, there's many ways we can discriminate. Again, many
Absolutely.
areas.
I just returned from the ASPPB meeting, which is the Association of State and Provincial Psychology Boards last week. And the overall discussion of CE came up, not in this specific context, but more generally. And there's certainly no agreement amongst all those people. These are people who represent regulatory boards from across the United States and Canada. But there's a lot of opinion that CE by itself does not change behavior. And if we're looking to change behavior, in terms of education or, some kind of a structured rule set, CE just doesn't do it. It may be good, but I know I'm aware, I've been taking CE courses for a long time, and I know there's a huge variability on the quality of CE workshops. I get mailings, advertising workshops here and there. And I get mailings saying, okay, here's the workshops in South Florida this winter that you can go to. So it was more the location, or on a cruise in the Caribbean, and you get CE credits and write the whole thing off. So there's quite a variability on, the quality of CE. Like I said, it's not a complete agreement one way or the other. But what they came up with was this notion of engagement, that the best way to ensure good behavior, high standards of behavior, is to have professionals be engaged in their profession, engaged in their work. Certainly not, the Lone Ranger out there doing stuff and coming up with ideas on how to, turn lead into gold and all this and that. But just being engaged with other members of your professional community, being engaged with the literature, being engaged with, just science in general, is the best way to accomplish the end that people seem to be wanting when they come up with CE. And Cindy, I'm not sure, but my own personal data, which I'm sure is impeccable, does not really support the idea that since Kansas has made ethics CEs mandatory, that has really changed the nature or tenor of the complaints of what the professionals in Kansas tend to do. In other words, I'm wondering if our mandatory CE for just ethics in general really is an effective way to get people to behave in a very ethical manner and not violate that. But that's my own opinion. I could be wrong.
So Bruce, are you suggesting that we eliminate all CE requirements? I think that's what I heard you saying.
No, I think we need to re-examine it somewhat. And as soon as I say that, I know it could just be this huge can of worms. Again, in my own personal experience, I've heard people get CE credits literally because they work in a mental health center and they all sit around the table and eat lunch together and count that as an hour of CE because they talked about a certain subject. Whereas, there's other CE events that are really top flight and you learn a lot and you're challenged and you're convicted about what you do and all this and that. I think we need to re-examine, what we mean by CE, and try to, in the name of protecting the public, make sure that CE is, a good quality and not some, like I say, not some Lone Ranger ideas out there.
And doesn't the board do that now, Bruce, or, don't we approve, CE, CEs in general? And if if BSRB has questions, they usually contact one of the board members, if there's some doubt of relevance to a CE. So I think we do have a process where we do examine those and to see if they're valuable.
I'm more familiar with psychology, and I know there's, all sorts of suggestions on how to conduct CE from APA, and it does, there's ways that you shouldn't, get there, sign your name in, then go out for lunch and come in, and, before it's over and get credit for the whole thing. You should have to take a post test. And the presenter needs to submit an outline of their presentation before the event. And that's not always true. CEs that we give credit.
Well, as an APA approved provider of continuing education, I could give you a list of all the requirements that we have to meet in order to maintain our approval status, right?
And I agree, but what I'm saying is that not all CEs that we give credit for follow those guidelines. I mean, those guidelines are great, but not all CE events follow those.
We're kind of getting further out. Do we want to look at making a decision on this particular item on our agenda? Rick, are you just going to move forward in your area and the rest of the committees have decided they will wait at this point?
Yeah, as long as the board doesn't block us, we'll go ahead and follow our conscience and our ethics to do that.
I've not heard any blocking of Rick's committee. So, all right, so we can move forward on that then. Thank you for your discussion on all of that. So the next item is continued discussion on records of deceased practitioners. David, you want to give us an update?
Yes, and before we move forward, just for clarity, I believe at the advisory committee meeting for licensed psychology, they talked about a specific method of moving forward on the recommendation. So I just wanted to clarify. It sounded like at the time of that advisory committee meeting, if there was going to be a recommendation to go forward, it would be to essentially require 3 hours in DEI, but allow for overlapping. So if those 3 hours also were ethics hours, you could take the ethics class and then it could count for both ethics and DEI. Or if you had a DEI that had a diagnosis and treatment element, you could do the normal diagnosis and treatment and it could count for that DEI requirement. So it wouldn't remove any of the existing requirements for ethics or diagnosis and treatment, but it would be a requirement that if you didn't do it with ethics or you didn't do it with diagnosis and treatment, you would have to do it separately. Is that still the understanding kind of going forward? Because I plan to try to start to get some of the legislative language down if that's still the recommendation.
Yep, that is precisely what I remember. Thank you, David.
Thank you.
Okay. And then Leslie, you mentioned the next topic, and that's the continued discussion on records of deceased practitioners. And this is something that I had worked on, and I appreciate the work of Laura Shaughnessy, because at the last meeting, the first day of the planning meeting, she volunteered to work with me to try to move forward on this. I think we all recognize that there is a problem, and that if a practitioner passes away unexpectedly and they're a solo practitioner, and there's no logical custodian for their records, they're not someone who works at a facility, or they already have someone outlined, what happens with those records? Or there are cases where records are abandoned. And we talked a little bit in the past about how, in terms of medical records, the Board of Healing Arts has a process in statute. They actually have a specific fund to assist them with going about and taking the records and then moving forward legally to name a custodian for the records. We don't have that. We're much smaller as an agency. At the last meeting, it was talked about that I think Cindy Arkle had offered up that Oregon was a state which requires practitioners to identify a custodian of records. And so Laura Shaughnessy and I met a couple times, and we talked about different ideas to move forward. We took some language from Oregon, and that's what you have in your packet. There are a few different handouts. One is sort of a summary of information that can be found through the website for licensed professional counselors and therapists. And also there's some language for psychologists in Oregon. In Oregon, they actually have a specific form that they have individuals fill out, which indicates their name, license number, and then it says, I designate one of the following as a custodian of my client's records, and it has to be one of an approved group, whether it's a licensed health or mental health care individual, records management company, an attorney, healthcare organization, mental health care organization, or school. And then there's some other information to provide on there as far as contact information to get a hold of that person. And then I provided some, essentially, some language for their provisions for what they have and essentially their regulations for what's required to name a custodian, both the psychological records and also the records of counselors. And I think Laura Shaughnessy also, we talked about different things that we had seen in this language, and she reached out to another individual who oversees different mental health professionals in Kansas. And Laura, do you want to add anything as far as some of the discussions we had?
Sure, thank you. We really decided or, thought about it breaking down to two things, a matter of ethics and protection of the public, to make, rules that would guide anybody who is in charge of records. I spoke with Kyle Kessler, who is the executive director of the Association of Community Mental Health Centers. He is the executive director over the 26 mental health agencies throughout the Kansas area. Is it 26 counties or 26 mental health agencies?
I believe it's 26 community mental health centers.
I think it's 26 counties, right? It doesn't matter. Anyway, he said that they had a conversation through all the staff about a year and a half ago, an ongoing text and email conversation about what to do. And when I explained to him, what we were thinking about, it really resonated with him that we do need guidelines that are formal and consistent. He really also resonated with the idea of, people being asked, but not necessarily guided, but not dictated what they needed to do with their records. And we said, our goal is really to just ask the question in the right place at the right time, and to make sure that people understand we're not asking for the BSRB to take over records. We just want people to have an idea of where the records need to go electronically and the actual physical copies of the records, because most of the time those things are accounted for, but as an ethical concern, all people who have records really need to be thinking about this. And we talked a little bit about, the fact that in mental health agencies, community mental health agencies, it's baked in. If you're in a practice, if you're in a, a mental health setting, it's pretty obvious where that someone else in that practice might be the person who becomes the custodian of records should something happen to you, but it still needs to be official. David, didn't you say that only a couple of times a year does something really come up at the BSRB where, there's not a logical custodian that's an obvious person in an agency?
Right. I think it comes up about twice a year or so.
So this isn't going to be, something that really taxes the agency, which or the BSRB, which I'm glad about that. But it's just something we all need to think about and have a plan.
Yeah, and I can add on to that too. I think, that there's a few different elements here. One is who would take custodianship of the records, and then, temporarily. And then there's also the issue of making sure that there's someone in place to be the more permanent custodian of those records, at least as long as they need to be held. And I think we've identified that there is an issue and there's a problem. It's not, it doesn't have a great amount of frequency, but it is frequent enough. And I think everyone agrees that this is something that we would like to be helpful at trying to create a solution here. In trying to really dig down into the custodianship element. I think that's a little trickier than I initially believed. The Board of Healing Arts has something in statute which allows them to use money from that separate fund to go ahead and move forward to have people named custodian. And I understood, or I thought, that the Attorney General's office, while they would seize records in certain cases, I think it's still the step that still we need to get fleshed out is what process is being used to name someone as the custodian of those records. And I think, in terms of the Attorney General's Office Consumer Protection Division seizing those records, it's very clear if there's a case where, the records are abandoned, where it's possible that members from the public, that they're not secure and people could get access to those records who shouldn't have access to them. I think in that case, I think it's clear the Attorney General's office would take. I think it's a little bit not as clear when you have cases where you may have a solo practitioner who has a spouse and the practitioner passes away, because the records maybe are in a place to where they are still secure in a manner. So I'm not sure, we still need to work with the Attorney General's office to really figure out, what steps we can take to really help in this process moving forward. And I think, honestly, I wanted to talk to all of you and just let you know, I think that's a conversation that we're going to need to have with the Attorney General's office to make sure that we're on the same page, because what I was going to come forward to you and recommend at this meeting was that we limit our helpfulness in this to have practitioners identify who would be the custodian of their documents, but that we don't try to get involved in the actual legal process of naming the custodian. And I was hopeful that would be something that the Attorney General's office we could work in cooperation on, but I think it's still a little early before we can move forward on that. So while I'd like to move forward on this now, I know that if we put something in place, licensees will have a lot of questions and they'll want to know what they need to do in the process. And I'm not sure we have that clearly defined in all the cases that would come about. So.
Okay, I guess we'll take that under advisement then, and I guess we'll have to discuss this at the next meeting then.
Yeah,
If everyone's okay with that.
And bring back if I don't want us to move ahead on something unless we know, because we will get a lot of questions and I want to make sure that everybody's on the same page so we can really be helpful, which is our goal in this.
Okay. So I guess we'll move to board governance policy, potential changes. I think that is in your board packet and there's a highlighted section if you all want to refer to that. And then David, you can go ahead and get started if you want to.
Great. So there's two documents here. One says Behavioral Sciences Regulatory Board Governance Policy. And at the top, it says adopted October of 2011. This was the last time that the board adopted a version of the governance policy. So it's been a full 10 years since the last time this document has been revised. And at the September 27th meeting, we just briefly started to talk about potential changes to this document. I was asked to go and look at this document to identify items that potentially should be changed. And so I put together an 8-page report for you. The top of it says summary of board governance policy recommended changes and items for the board's review and consideration. And so I just kind of wanted to walk through that document. So you have a copy of the board governance policy as it looks today, and then the other document. And for items that I have recommended I have highlighted in yellow on the 8-page report. And for items that I just wanted to bring to the attention that the board is aware, I wanted to highlight that those items are in the governance policy and allow the board to have discussion if you would like that item to stay in the policy, or if you would like perhaps to look at something different. So I haven't really taken a position on any of the blue items. I just want to make sure that you're aware of those and allow you to vote on those or not vote on those for your consideration. But I did outline on the first page of this report sort of a breakdown of the current board governance policy in terms of the different sections. And I also mentioned at the last meeting too, when I was asked to take a look at the board governance policy, I went about trying to find other references to similar policies from other agencies. And when I contacted the Department of Administration, they weren't sure how many other agencies had a board governance policy. So we went ahead and put out a poll to non-cabinet level agencies, and we got feedback, and only a small number of those actually have a board governance policy. It was a handful. Most of them said they did not have one. And so I believe the language to me, as I've done research on other entities that have governance policies, is it seems like the language in the board governance policy seems like something that you would have more frequently with a corporation or a business, that there would be a board or a governance policy for something like that. So when it comes to state agencies, it is somewhat rare to have a governance policy like this. Also, in terms of the rules that govern state agencies, it's important to know that first and foremost, as a state agency, the BSRB was created by the Kansas legislature, and thus it's the statutes and any kind of federal statutes, but the statutes that have the biggest priority in terms of the rules that are followed. And then secondarily, it would be any kind of regulations. And then it would be third, it would be anything that the board chooses to follow in terms of the hierarchy of the rules governing the board. And if there are conflicts, the statutes and the regulations have to take priority over anything that would be on that third level of governing the board. And
So if I can interrupt, David, so the board governance, we have the option, not saying that anyone is choosing this, but there is an option of doing away with the entire board governance document. So that is what you're suggesting, is that's one thing we can do, or we can move through and make these changes and update it, or not do anything to it at all. So those, I think, are the 3 areas that we need to kind of be thinking about throughout this.
Correct, because in looking at the rules that govern the agency, first and foremost, those are in the statutes and or in the regulations. And I'll highlight some of these as we go through here, but some of the references to language regarding the board or even staff of the agency, some of that is already in statutes and other places. So it's something to consider. Do you want to have this in 2 different places, or do you want to let the existing statutes and regulations hold? So there is still a question of, do you want to keep this as another document? And so a lot of the changes that I've highlighted are under the assumption, if you do still want to keep this as a document, here is what I would recommend in terms of cleaning up some of the language. But it is still, a question for the board. Do you really have a need for this type of document, and that kind of question. So. And there are a number of things that I've highlighted in the document. I think it would be helpful to sort of get some discussion on each item as we go along. And if the board feels comfortable, making a decision on each one, that would be fine. As I mentioned, this is the first time in about 10 years that it's been modified. And so if there is something, it doesn't have to all be completed today, at least in terms of my position on this. I'd like to support you in terms of whatever decision you'd like to make as a board concerning the governance policy. but some of these are items that maybe would require a lot of discussion. And so, you know, your deadline in terms of finishing this is your own deadline. It's not something that has to be submitted. So just wanted to highlight that too as we go through items.
There any comments before we get started? Is anyone thinking that this is not something that we want to even move forward with? We don't want a board governance, or do we want to proceed with looking at the changes that are necessary?
Yeah, that would be my question. And before we review and discuss, I mean, wouldn't the question be, do we want to, you know, edit and keep revise the 2011 or not have it at all?
Correct.
I'm curious as to David's opinion, David Fye's opinion about this, just given his background and familiarity with state government.
You know, I'm a bit torn because I do think that there are questions that board members have, especially new board members, in terms of their responsibilities. But in looking through here, there are a number of things that I'm not sure that the board really has jurisdiction on. You know, I'll highlight that for you if you're going to go through this, but there's also, you know, in general, I think outlining expectations is helpful, but I also feel like if there are things that, you know, the board may not have authority over, and I think also from a public perspective, you know, the public's going to look to see what information can I learn about this agency or that agency. And so it can create some confusion if you have a document like this that may not be enforceable for one reason or another. So I think maybe potentially there are sections of this that might be helpful as a separate document. For example, on the BSRB website, there is a document that talks about the complaint review committee process. And I think outlining that is helpful. I think there's a website posting policy that's also helpful, I think. But in the way that I read this document, I do have some concerns about it. And so I would say in its present sense, if it was to just take this as it is or not have one, I would recommend probably doing away with this because of potential conflicts with the statutes and regulations. If it's modified, you know, I ultimately work for the board, so I'd like to do what you would like to do on this. But the way that it's worded, I do have some serious concerns about some of the sections.
Just a quick follow-up. So it sounds like there could possibly be a need for some sort of document to outline, I would call them more board member expectations or resources, and maybe just a retitling of whatever we're doing.
Yeah, and I also think, you know, the last part of the document deals with advisory committees, and because the complaint review committee process is its own separate document, I could see the advisory committees being a separate document too. And one reason for this is because in the statutes, there's no specific mention to advisory committees. It does mention subcommittees, and I think that's where the advisory committees fall under. So it might be helpful to kind of see some more information on these advisory committees based on the role they play. But I think in terms of a lot of the other information as it relates to board and as it relates to staff members, I'm not sure that you have a need for that based on what's already in statute and in regulations.
There were also some additional information in the board governance policy that are things that, like, when a board member is appointed, we don't have jurisdiction or any way to govern that. And so there's some issues there too. When I was reading through, I thought, well, we can't enforce the conduct of a board member. That's not something that the board does. That's more for when they're appointed or who they're appointed by.
And I can add a little bit in trying to really assess the board governance policy. I've had a few conversations with Mark Skoglund, who's the director of governmental ethics, just to see, you know, how would this fall in terms of the jurisdiction of the board, and some of the language in here in terms of limitations on what board members can and can't do, or staff. And what he indicated is that their office does have a short training. It could be 20 minutes or half an hour that talks to a lot of these issues, because those are included in other statutes and regulations. And he said he would be happy to come and talk to the board, do a brief presentation. And so it may be helpful for the board to kind of, have a short presentation from him, if you would like to have a document like this, just to already know sort of what's out there in other statutes and regulations, so that you don't have something in a document like this that might conflict with those. So that's one thing too. I didn't go ahead, and I told him that it could be something the board might want in the future, but I said I wanted to talk to you as board members first to see your thoughts on something like that. We had a training earlier this year from our legal counsel in terms of board member responsibilities and advisory committee members' responsibilities. But I think specifically to the issue of things like financial benefits and different limitations on you and your role as a board member, I think that could be helpful to hear from him in the presentation, if you did want to evaluate what to keep or what not to keep in here as it concerns those items.
I just have a quick comment. As a new member, this is helpful, but I also spoke with David several times and he gave me the same information. So I don't know if it's necessary to have it all written out.
This is Jane. Oh, I'm sorry. I didn't mean to interrupt you, Leslie. I
You're
was just
fine.
like,
Go ahead.
I couldn't find my mute button. I couldn't unmute myself. I was just going to say, as far as I'm wondering, as I've been sitting here listening to this, some of my other boards have, they don't necessarily call it a governance document. That I don't know if that maybe was the term that threw people. At the present time, we're working on one with the Board of Technical Professions, and they're just calling it a board member orientation, which as I'm flipping through this looks like a lot of the same information. And I do know, I mean, the veterinary board, we put something together, but we gave it a different name. So I don't know if it's a matter of maybe the semantics of it, if what you had requested that, because I have no other board that refers to it as a governance document. My Board of Cosmetology is actually just a outline so that the executive director can check off the points to ensure that they had heard that. And then the majority of my boards will have at least once a year a ethics training to ensure, like, when you can take a meal and if you can accept the coffee cup and all that. And so I mean, the ethics part of it, but the other part is to, when you're on this committee, this is what this committee does. And when you're in this role and when you're able to speak without ensuring people realize you're not representing the board in that aspect. If you go to like a state conference or something, you're not there representing the board, you're there because you are the licensee. So I just wonder if it wasn't maybe the term of it for governance. It's pretty long, that's for sure. But I just wanted to.
I agree with you, Jane. I think it takes on a different meaning because of that word as well. And there are some things, and I'll just tell you, there's some things listed that the chair is required to do. And, we've run into maybe a conflict on that. And my opinion always is if it says board governance, that means that we're supposed to follow it. And if we're not going to follow it, then we either need to update it or we need to get rid of it. So that's kind of the situation, as a chair, we have to follow this governance policy, and it's not aligning with maybe our current ideas of how we want to function as a board.
This may be a difficult question, but can anybody speak to 10 years ago what was the reason this was created and adopted, since we're having questioning now? I just wonder if there was some specific reason or some piece of it.
Well, and Leslie Allen has been with the board longer than me. I think she's been with the board about 20 years. But in talking with her, and Leslie definitely can add on after this, I did ask her if it was created back in 12 or 11, and that's not when it was ultimately created. That's the last time that it was revised and adopted. And I think that probably explains a little bit of some of the odd word choice in some of it, because some of it just doesn't mix with other terms within the document. So it's internally inconsistent in certain places. I was trying to figure out when it was originally created, and I'm not 100% sure, but it does go back prior to 11. And do you have anything more to add on that?
No, I think that when it was created, the professions were really starting to come together and try and form a cohesive group. And that's not the case anymore. I mean, you guys seem cohesive. But that was what was kind of going on at the time it was created.
Yeah, so I think it must have been at one point, even further back from 10 years, a longer document, because, for example, it's a definition section, but some of those definitions in the definition section don't appear in the rest of the document. And then there's things that talk about, terms of advisory committee members, but it says they should come up every 3 years, but that doesn't really make sense with the rest of the way that it's worded. And so I think it was maybe a long time ago, a much lengthier document, and then it was cut down and revised. But in its present state, there's a lot of issues. And, as other statutes and regulations have changed, some concerning ethics, I'm not sure the provisions in here are still up to date with what is currently understood for staff member or state employee responsibilities or board member responsibilities from some of that standpoint. So, in terms of my review, I looked at it and said, if we want to keep this document, here are some changes that I would make to clean it up and to try to make it better. But for the reasons we've talked about, there is still that question of, do you want to keep this in its present form, or do you want to do something different with it? And just one of the things I wanted to highlight too, because I'd be happy to go through here and sort of summarize the changes that I had recommended, but just as an idea of some of the, potential problems. There's one wording back. It talks about board member integrity, and it says, a member of the BSRB shall have no criminal or professional misconduct record, nor is under any investigation or charges or complaints. But it says they shall. And while it would be an expectation of board members to be at the highest level in terms of ethical conduct, we have a responsibility as the BSRB. If any licensee is charged with a complaint or we receive anything, we investigate those. And so when it says they shall not be under investigation, a licensee has no control over that. So any board member who's a licensee, it creates some internal conflicts. And there's more examples of that when you go through the document. And so
And some that belong to the governor. The
Well-
governor makes that decision, not the board.
right, and ultimately in our statutes, it talks about, the governor chooses who serves on the board. The governor makes those appointments, and it's up to the governor's purview as opposed to something the board would decide. So. But as I mentioned earlier, in terms of, my personal opinion, I've kind of tried to lay out my thoughts on the document itself. I do think that there are some questions specifically concerning the advisory committees that if you don't keep this in its present form, I think it would be helpful to at least have a separate document that addresses the advisory committees, because as I mentioned, those aren't really in statutes except for a reference as subcommittees. So I think in terms of, letting the public know how those operate, I think it would be helpful to have some document like that addressing the advisory committees.
So it sounds like as we review this, we can just see what content is in there that would be appropriate for our new yet to be named document.
I think we could maybe start from the top and go through, I would assume pretty quickly, some of the items that, you know, are listed there, David, Fi.
Okay.
And we could probably strike it pretty quickly. Just in the discussion that we just had, it sounds like a lot of this is not going to pertain to the board if we do adopt a different document. So would it be okay with the board if we just kind of start at the top and look through pretty quickly some of the items? And then if there's any comments, would that be okay? Shaking of heads. Yes. Okay. Thank you, David.
Well, I apologize for not numbering the pages, but I'm going to start with page 2. And I did number them. So this is potential change number 1. And this just has to do with, should we keep a document like this? I think it's important that we outline where it would fall. As I already mentioned, the statutes and regulations take precedent, but I think putting that out explicitly would make sense. So I recommended adding language to the beginning of the document that says, insofar as the board governance policy conflicts with or limits any federal or state statute or regulation, the statute or regulation controls. So that's one thing that if we do keep this document, I think making sure the authority is there is important. The second is more of a cleanup type of change. The board uses terms like chair, chairman, and chairperson interchangeably. And for consistency, I had down to change them all to chair and do the same for any references to vice chair. The third item for potential changes has to do with frequency of board meetings and also corresponding reports. When this report was, I think, put together, the board was meeting every month, but currently the board meets every other month. So there's a reference that the board meetings take place the second Monday of every month. But I would recommend making that consistent with the current practice of the board to say that they meet every other month. And then it does indicate in the current policy that the executive director shall keep the board advised of BSRB activities by issuing a monthly report. But then again, as the board meets every other month, it should be, what I would recommend is a report at the board at each full board meeting. So should the board meet for a limited topic, such as, the board planning meeting / retreat, or if there's a certain bill the board needs to weigh in on, it wouldn't involve that. But every full board meeting, the executive director's report could occur. On the next page, potential change number 4 sort of outlines some different language on board members' code of conduct. As I mentioned in the little summary explanation here, the determination of the qualifications for board membership is outlined in statute, but ultimately it's up to the governor's discretion. The governor does appoint BSRB board members. So a number of the clauses that say a board member shall, it also says that a member of the BSRB, which is a little confusing because a member of the BSRB in this context refers to board members, but you also have staff who are part of the BSRB, and you have licensees potentially which are under the BSRB. So a member of the BSRB, I think, should be changed to board members to clarify that. And then, as I mentioned, that for that example, that talked about a member of the BSRB shall have no criminal or professional misconduct, nor is under any investigation of charges or complaints. Anyone can file a complaint. We have a duty to investigate that. So board members have no real control over that. So I had some different language on that item to recommend that a board member of the BSRB should have no criminal or professional misconduct record, nor commit acts that would lead to investigations or complaints. So trying to clean that up and make it a little more consistent with what I think the intent of the document was. And then I changed the number of the shalls to shoulds. And then I think Rick had his hand up for a question.
Well, yeah, it's right there in that section. I understand we wouldn't want to try to limit and can't limit the governor's office on appointments. Some of those items, though, don't seem like they're government or their governor appointment issues. Like number 5, a board member of the BSRB shall or should reveal actual or perceived conflicts of interest. Why would that be a should instead of a shall?
I think it comes down to the ability or lack of the ability of the board to remove a board member.
Okay.
The actual statutes for the BSRB don't outline a policy to remove board members. So it just kind of comes down to, if these are expectations, that's one thing, but if they're shall, it would lead me to wonder what the teeth are, because it's a prohibited action. But if the board can't remove a member for that, then
Okay,
that's kind of why I changed a lot of them.
And
so I can have a conflict all I want, and it's just kind of up to me.
Rick, if you keep in mind, that can also be covered at board orientation, new member orientation.
Right.
So this does not have any more teeth than if we met with
Sure.
the board member initially, right? So I agree with you, but we don't have any way to, to address that.
Yeah. Okay, that's too bad.
Well, and I think, for licensees, if there is some violation of a professional rule of conduct, that could be some grounds for potentially a complaint under the BSRB. But in terms of the responsibilities of board members, as a document that the board adopts for themselves, it just has to do with sort of a jurisdictional issue, I think. But that was sort of my thought process on why these were changed. But just to make it absolutely clear, I don't think that would be something that should be allowed. It's just, that's the reason why I recommended changing it from shall to should.
Of course not.
And the same kind of goes for the next section that deals with conflict of interest and compliance. Just had a number of items that said shall, and based on the same reasoning, changed the number of those to should. There is a last item which talks about a board member of the BSRB using the agency's name or agency information for personal gain. And the actual wording right now refers to a member of the BSRB or staff shall not use the agency's name or information for personal gain. And so if this was something that was going to be kept, I broke it into two different things, because there's board jurisdictional items, and then there's staff jurisdictional items. One thing to consider is whether you want to include language relating to staff in a document like this. In going over this, I think one concern would be, I wouldn't expect all of the members of my staff to be familiar with something called the board governance policy as it relates to them. As a state employee, there are things in place in the statutes and regulations that govern what they can and can't accept. And as I mentioned earlier, the Department of Governmental Ethics would be happy to provide information on those as they relate to state employees. But including something like this that talks about staff might be a little outside of a governance document for the board. Just something for your consideration. But that's sort of why I broke it into two, because there's a different authority based on if it's board members or staff. But then there's also the question of, do the rules as a state employee under the statutes and regulations already govern that topic? Is it needed in here? And then there is a potential change number 5, had to do with the definitions. And it has to do, there's direct financial interest, indirect financial interest. However, these two definitions don't appear anywhere else in the document. I think they were probably in reference to items that were pre-2011. The governance document does define pecuniary benefit, but that term is only mentioned in the governance policy within the definition of direct financial interest. So I really, based on my review, I don't think these definitions really play an important role. I think maybe they were involved in some other language that was there previously, but I think probably this definition section entirely could be struck. So wanted to highlight that for you. The next one, item for board review and discussion number 1, that's the yearly formal evaluation of the executive directors. The board governance policy indicates that there should be monitoring of the executive director's performance, including language that the board shall formally evaluate the executive director on an annual basis, with emphasis on whether set outcomes are attained. So I wanted to draw your attention to that to make sure that you are aware that is currently included in there. And if you would like to do a formal evaluation of the executive director, that's perfectly fine. I just wanted you to know that that's included in there if you want to keep that. And then there is a process I found to go ahead and assist the board if you want to do that yearly performance. but that is something I wanted to make sure that you knew was included in the board governance policy.
And again, we don't have to have that included in the board governance to be able to do that, to have that performance review.
Correct. And for all of my staff, when I came on board, we implemented something where we do a beginning of the year planning meeting with all staff members in the first quarter of the year. And we do a mid-year check-in and we do a yearly performance review. So having something like that would be no trouble at all. It's just, do you want to include something like that within the board governance policy is kind of the topic. The next item the next topic has to do with advisory committees. As I mentioned before, advisory committees are not specifically included in statute or regulation, though there's a reference to subcommittees, which is sort of where the advisory committees fall. Potential change number 6 has to do with the structure of the committee and has to do with professional board members. It mentions in the board governance policy that the chairperson of the committee will be a board member licensed in the discipline of the committee, and a public member of the board will also be a member. However, there's no other language included in the board governance policy that talks about board members serving on advisory committees. However, there are currently 2 board members in licensed psychology and 2 board members in social work. And so the board really doesn't talk about having that other member on the advisory committee. So I recommended including some language. And then also the language said that the chair would be someone licensed in the discipline of the committee. But as we've talked about at board meetings in the past, sometimes individuals hold more than one license. And so it has followed that they are not only licensed in that area, but the chairs of the advisory committees have been individuals who were appointed by the governor to represent that specific profession. And so the language that I recommended here was that the chairperson of the committee will be a board member licensed in the discipline of the committee and appointed by the governor to represent that discipline on the board. Any other board members appointed by the governor to represent that discipline on the board will serve as a member of that advisory committee. So that addresses the second social worker and the second member from the licensed psychology profession. And it also addresses, as opposed to being licensed in that profession, it's someone who's appointed by the governor to represent that profession on the board. Potential change number 7, structure of the committee. Reference to certain attendees. There was some language that basically indicates that the credentialing specialist and the assistant attorney general representing the board are encouraged to attend. Currently, right now, there's no employee for the BSRB who holds the title credentialing specialist, but I believe the person who fits that most would be the assistant director and licensing manager, Leslie. And also, we have a number of advisory committee meetings. There's 7 different professions, and those advisory committees meet frequently, usually every other month. And because of how our contract with the Attorney General's office has changed over the last few years, there is a formula for how much we pay to the Attorney General's office for services. And so while I think it's important that they are there to assist us when needed, I don't think what I would recommend is for them to be expected to attend every advisory committee meeting. So that's why the recommended change would be the assistant director of licensing or this assistant director or licensing manager is encouraged to attend the meeting. The assistant attorney general representing the board should attend meetings when their attendance is requested. The next item for the board review and discussion is the number of non-board members on an advisory committee. The language currently indicates that there will be a minimum of 3 additional members appointed when you take out the board members. So members of the advisory committee that are non-board members, it says there will be a minimum of 3 additional members, but it doesn't list a maximum number of members. I've heard it discussed that there was sort of an expectation that there would be no more than 10 non-board members on the advisory committees, but the language is not included in the advisory committee or the board governance policy. So if you would like to limit that to that number, that is something that you could consider and add. There is some language in the board governance policy that states BSRB board members may serve on the advisory committee, but that sentence is a little confusing. It's a little bit vague because most former board members are licensed in different areas. And so if they are a licensee, then they would be able to nominate themselves for consideration. But it sounds like in the past, there was a practice where members of the board, when they come off the board, may have been able to serve on the advisory committees by going directly from the board to the advisory committee. And if that's the intent, if that's something the board would like to have, it would be helpful to clarify that language in something like this so that we know that's sort of the way that the board would prefer. The next item is item for board review and discussion number 4, representation of advisory committee members. So there are a few different sections as it refers to advisory committees, and I've tried to pull information out from the different sections to assist the different advisory committees that are reviewing applicants and selecting members. In terms of the structure of committee section and the selection section, there are 3 specific statements concerning criteria that should be considered when individuals are reviewed for potential advisory committee membership. It says, these members shall provide representation of the levels of licensing for that discipline. Another sentence says, it is suggested that those members be selected from among public and private practitioners and educators. And then another line says, in reviewing nominations, the committee should work to ensure there is representation based on geographical, gender, and public versus private settings. And then there is some language under the structure of committee section that states, quote, the policies and procedures under which the BSRB board members are expected to operate will apply to the advisory committee members. But it's unclear if that is one of the criteria that should be used. And so I believe it does fall under the section when looking at individuals who could serve on the advisory committees. So it kind of opens up the doorway, but it might be helpful to clarify exactly how that relates to the selection process. And then second, I've identified these bullets as items that deal with specific items for the representation of advisory committee members. There have been some questions about, are these all the areas that the board should be looking at or advisory committees should be looking at when evaluating candidates? So if there's more criteria that the board would be in favor of specifically looking at when looking at members, that's something that the board could consider adding here too. The next item is item for board review and consideration number 5, 2-year terms, 4-year maximum. So the language in the governance policy says for the structure of the committee that the terms of advisory committee members will be 2 years and that members may serve up to 4 terms. So 2 years up to 4 terms. And so that would be 8 years. In the past, terms of service, it sounds like in some cases have run together. However, if the board wants to keep this policy of it being 2-year terms, and you can have 4 terms, then what I would probably do is I'd probably put a list together every spring. And then similar to the way that board members can serve 2 4-year terms, and then at the conclusion of the 4-year term, the governor can reappoint board members. That's probably how I would interpret this and bring those list of names to the chair of the board to go ahead and reappoint those members for another term. As I mentioned, it seems like the practice in the past has been that those 2-year terms kind of run together in most cases, but I'd like to make it a little more formal of a process and kind of clean that up a little bit if that's something you would prefer to use going forward. The next item is staggering of advisory committee terms. That's potential change number 8. The board governance document talks about appointments of the committee should be staggered so that approximately 1/3 of the committee members will be expiring each year. While staggering appointments is a preferred practice, if advisory committee members serve these 2-year terms and members can serve up to 4-year terms, it's impossible for 1/3 of the committee to be expiring each year. So this is some of the language that I was talking about earlier where it's internally inconsistent. Based on the amount of terms and the length of terms, it's not consistent anymore. I think maybe there used to be 3-year terms potentially, and then that could be interpreted that way, but we're going to call your attention to that. So what I recommended was appointments to the committee should be staggered to avoid having too many members of the advisory committee reach their maximum length of service at the same time. The next is potential change number 9, changing terminology of nomination to recommendation. So the language in the governance policy selection section talks about members of the committee may be nominated by anyone, including the public, committee members, members of a professional association or organization, either the discipline's own or other, or through self-nomination. The language further states the committee as a whole discusses the nominations. The section then states the chairperson of the committee will submit the names of the nominees to the BSRB board chairperson at a board meeting. And then the overuse of the term nominations is really the problem here, because it says members can nominate themselves. And then it says a list of nominations from the advisory committee will be forwarded to the board chairperson. And what I think is probably intended was that the list of nominations will be considered by the advisory committee, and then the advisory committee will reach recommendations, and those recommendations should be forwarded to the chair of the board for consideration. And so that's why I recommended that the language be changed to the committee as a whole discusses the nominations and reach recommendations on new members. And then the chairperson of the committee will submit the committee's recommendations for new members to the chair of the board chairperson at a board meeting. There's one little additional thing here too, and that, as I mentioned, this language put together back when the board met every month, and it indicates that the list of recommendations will be provided to the board chair at a meeting. The board chair will have the opportunity to have additional input before making a decision, which we made at the following meeting. But since the board meets every other month now, that's quite a bit of time. So I've tried to create a formalized process, taking into account what I think was the intent when these rules were written, to make sure that the chair of the board has that information with sufficient time to collect additional input before reaching a decision. But if you would like to keep this process, I'd recommend removing that is provided to the chair at a meeting and then decision made at a following meeting, because that would create a long stretch of time in between this process. And then number 10, potential change in number 10, notification of advisory committee members. It also states that after the appointment has been approved, the executive director will inform the advisory committee by letter. This was written back before our communications were kind of what they are now. Most of our communications are over email. And so as a little cleanup, I recommended that it be changed to after the appointment has been approved by the executive director, will inform the advisory committee by letter or email. So you can leave that as an option in case we can't get a hold of them through email. But I think with the expediency being the priority on some of these things, I think that makes sense as cleaning things up and making it more up to date. So as I mentioned, these were changes that I recommended or items that I wanted you to be aware of for your consideration, and then to decide if you wanted to keep these things in. So I guess I will stop right now and answer any questions if you guys have any questions about any of these potential changes. But this was my best attempt to take some of the inconsistent language and the current practices and make it a little more clean with some of the things that we do currently.
So before questions, if I could just interject here, are we seeing, is there anyone who has a comment about keeping this document? Do you see that any benefit to this, first of all? Is there anyone that wants to comment? Putting you all on the spot.
I like the idea of something like this. It really feels more like a policies and procedure handbook, just here's how we want to be seen. Here is how we want to operate. But I don't feel the need to keep this particular document.
I agree in terms of its usefulness for new people coming on to the board to be able to have something to review, and particularly because part of what they're going to do is then be in charge of an advisory committee and likely having to add members, so having information about that. However it is kind of defined, I thought the information contained within it to be available to board members to check on every time they have a question or wonder about something. It's always great to contact Dave. He's always very responsive and helpful, but to have something that they can just reference whenever they have a question, I think seems like a good idea.
So do we want to include this in the board member orientation manual that we receive? and not call it a board governance document.
I like that idea.
Okay,
I do too.
anyone opposed to that? I see no one. Okay, so David and Leslie, I guess that gives you some direction on where to change the document to its location and maybe naming it something different. What about the changes within? I think that's the next thing we need to tackle.
Well, I support the recommended changes David has made.
Me too.
Me too. And I just want to put a plug in for the 10-member maximum on the advisory committees. I won't get into the details, but there was a reason why that even came up in my advisory committee. So it seems like a good idea to have some sort of limit, much more than 10, and I think it's hard to manage in some ways, just my opinion.
Agreed.
I agree.
So 3 to 10, minimum of 3, a maximum of 10.
Yes.
I just want to say, David, I appreciate your work on this. I think your efforts, your expertise in this area has just took a lot of pain for the board out of this project and moved us along very quickly.
Thank you.
I
I
agree.
appreciate that. So just to make sure I understand, the highlighted sections in yellow, those are recommended changes. The items in blue are more items for the board to take a look at and then decide if you want to change something or leave it the way that it is.
So the first one in blue is it the will of the board for this language to remain in the governance policy?
And that had to do with the language that talks about a yearly performance review for the executive director.
Now, is that said anywhere else in life besides this document?
Exactly.
So I think under the Department of Administration, it does call for all employees to have a performance review annually. I think that would cover that for employees. So you could, that's what I'm familiar with that existing.
So we can strike that. Any opposed to that? Okay. We'll strike that then.
By the
Next
way,
one, sorry.
in terms of if you ever want to do a performance review on an annual process, I'm happy to provide any materials you all need as a board. Just let me know. I'm definitely not opposed to a performance review, but part of it has to do with you want to include in this document. So.
Right, and we discussed that. We can add that to another board meeting, the performance review.
And just for again, a lot of board members are new and I won't be at the next board meeting. This board was not terribly great at getting the previous director an annual review. So it was kind of in my mind when we hired David that we were going to do better. So just saying.
Yeah, so expect that coming up is what we'd planned.
To that point, though, if the board, however it's configured in the future, doesn't know where to look for that, right? By keeping it in some kind of document that we would see on a regular basis, it might keep the performance review in mind, right? So if it disappears into regulation or statute that we may or may not look at, we might not be any better than maybe we were about performance reviews over the last 10 years, you know?
I think that's a good point, Rick.
Was there a time frame also included there? Sorry if I missed that. When that annual review would be completed?
The language says the board shall also formally evaluate the executive director on an annual basis with emphasis on whether set outcomes are attained. But that's all that it says.
I would wonder if we would want to put a time frame to hold us that much more accountable as well. Otherwise, we'll just keep on pushing it down the road.
Yeah, a lot of groups just build it into their kind of calendar on certain times they start that process knowing that it'll be completed generally, before the end of the year.
Since it's yearly, would it not be a year from the time that position started?
That's probably why it wasn't listed, because then you run the risk of potentially doing some sort of big review 1 month in. So I don't know.
Someday.
Each calendar year, a review shall be done each calendar year.
Gotcha, that sounds good.
I don't know.
That's, I think, what the state statutes say for state employees.
Or within 12 months of hiring, and then every 12 months after.
Mhm. Either way, or
Yeah. And we are right there with Mr. Fye. It's already been a year. Time flies when you're having fun.
So just to keep me, making sure I'm tracking, did we go from eliminating that to keeping it in and specifying a date in the last,
That's what I'm hearing. Yes.
sounded like?
So we'll put that back, David Fye, and maybe change the wording to calendar year and every 12 months thereafter, as Deb suggested. That will be included on our agenda at the next board meeting.
Not to make this complicated, but to help out the executive director, I wonder if it would be useful if the board identified materials that the executive director would put together for that review, so that it's not, I know that my employees don't really like getting evaluations when there's not materials asked for. That just seems like it breeds uncertainty.
So I am in possession of a document, and then I think at the next board meeting, we're going to have an executive session to discuss further details in forming a committee.
that's good.
Will that suffice, Rick? Okay, thank you.
Okay, I think the
Sorry,
next-
David, I got lost on which number we're on. I was scrolling. You might have to help me out.
So the next one, and I apologize again for not numbering these. This is item for board review and discussion number 2. It's the number of non-board members on the advisory committee. And that's the one that essentially said that there is language that there should be no fewer than 3 non-board members on the advisory committee, but it doesn't indicate a maximum. And the question I posed was, should there be a maximum number of non-board members on the advisory committee? And if so, what should the limit on non-board members be?
I think Deb said 10, and I didn't hear anyone. Is anyone opposed to that? Okay, no one's opposed to that, so we can set that at 10.
Okay. The next item would be former board members on the advisory committee. There was that language in the board governance policy that says BSRB board members may serve on the advisory committee. And so it sounded like there maybe had been a tradition where some members of the board had moved from board membership to the advisory committee. That it might be something that had been offered to board members as they come off the board. And if that's the case, just wanted to clarify that so we would know what to do moving forward. So just kind of wanted to offer that up for the board to see what their will is on that item.
That could be a bias. We're making that decision for ourselves.
Is that like pay
I don't
raises?
have any problem.
Is that like pay
Sorry,
raises
Deb.
in Congress? My feeling about this is to be silent on the matter. If a former board member wants to serve, then I think they can apply like anyone else. I don't think necessarily they should have a green light go. But I don't think they should necessarily be precluded, because then you can get into timeframes. I served on the board 10 years ago. Now I'd like to be an advisory committee member. Are we going to have some sort of issue with that? My
But it
feeling is,
does say may serve, so.
yeah, I understand. I don't know. It sticks in my mouth to have some sort of a easy, I don't know. I just think it puts the chair of that committee in a weird place, potentially. I don't know.
I would agree, and it also limits, new people, new experiences, which I think enriches the board as we change. So, because that would be another additional 8 years or something, in addition to maybe the 8 years,
Some of us have already served on advisory committees. That would have me attached to this board for 20 years.
Yeah, I mean, fun. I mean,
Yeah.
I mean, we like you,
That
Deb.
doesn't seem right.
20 years. Oh my God.
So what do we want to do there, ladies and gentlemen? You want to keep it there? And
I
then-
like- I like
Go
the
ahead,
idea
David.
of them having the ability to apply, but not have a implied kind of invitation.
Mhm.
And I guess
I
the way
think
that
it covers that.
Yeah, the way that we would interpret this is that if that sentence was struck, it doesn't prohibit board members from serving. It just doesn't have an potentially automatic entry onto the advisory committee either. It would,
Not a green light.
what you said, it would treat them like any other applicant, more or less.
Mhm.
Because it said may be offered. They may serve. So I think it covers that. Okay.
The next item is this item for discussion number 4, representation of advisory committee members. And this is one that I had talked about, that there are several preferences that are highlighted in the section talking about advisory committees, that the members should provide representation on levels of licensing. It is suggested those members be selected from among public and private practitioners and educators. The committee should work to ensure there's representation based on geographical, gender, and public versus private settings. And then there's a reference that the policies and procedures under which the BSRB board members are expected to operate will also apply to the advisory committee members, which I believe could open it up to allow members of the advisory committee to use any of those things that were talked about earlier in terms of the confidentiality and ethical type issues to apply when evaluating candidates. So there's a question of, is this list the list that you would like moving forward? Would you like there to be any other items specifically listed in that section? And then is that section that the policies and procedures under which the BSRB board members are expected to operate applying to advisory committee members, is that something you specifically would like identified as one of the factors when you're evaluating candidates?
Well, I think that section 0.3 should be broadened, especially since our discussion with inclusion. I mean, I'm surprised that there's not a category for culture or race. I mean, I just, it seems pretty limited. Seems like it's excluding a lot of important categories.
What do you suggest, Carolyn? What do you think it should
Well,
say?
I don't know that I have a suggestion. I just think that we should broaden and add different areas. We've mentioned geographical area representation, that's important. Gender, public and private, but what about culture, cultural diversity? I think that's really, really important,
Mhm.
and that's not on there. We could break down some of the other categories as well. How do other people feel about that? I mean, we've used this for some time, and I think that when we look at candidates, we look at all other issues, length of experience and specialties they each bring. But I think culture, I just am surprised that's not on there. And I don't know how you would. go back, 'cause when you get these applications, a lot of that information is not on there. I don't know their cultural identity or anything really, so it's hard to even.
No, it's not. And we actually did that as part of a couple of times ago, specifically asked advisory committee members to identify folks from different cultures or people of color that they knew that might be good to serve on the committee. And so that's how we handled that. So I don't know if, I mean, I think what you're saying has merit. I want us to just avoid any kind of overly like the shalls. I mean, you know, it depends on who applies. I don't always have a LAC on my committee. Those folks tend to have direct service jobs and can't always break away to attend a BSRB advisory committee meeting. So, or they're just don't tend to have the interest that sometimes other folks have to attend something like that. So just my 2 cents on shall.
I agree, and a lot of LMLPs are working towards becoming LCPs, so it's seen for a lot of them as a temporary state. And they tend to be people, you know, fresh out of school who are busy trying to learn and feel competent in their jobs. So I like the idea of trying to get a broad representation, but as you said, sometimes we get a lot of people who apply and sometimes we get very few.
So there's one comment I wanted to add to this, and I definitely don't want to prohibit any board members from discussing, because I think this is a really good topic of conversation. One thing that I would recommend in here is potentially saying maybe something like among other factors, just to make sure that it's not interpreted as these are the only criteria that should be examined. I know it could become difficult to figure out all the different things that should be listed under here, but I think maybe phrasing it that way would open up the door to allow other considerations without people feeling that they're restricted to just these categories.
Well, I just have a question on why are we going to go with Carolyn's idea about including race, ethnicity, and culture, or should we just remove gender entirely? I don't see why we would keep one without the other.
And going along with kind of what Deb was referring to, it says should work on, and my thinking was to the best of our ability. I mean, some wording there that might indicate that, you know, if that person did not apply, or like you're saying, an LAC, that, you know, we did the best we could in locating these particular items here, these people. So
that seems to already be in the third bullet point. It's just missing in the first and second.
Should work to ensure would cover that, you think, Rick?
Or just should. These members should provide representation, as we've established. Should doesn't mean has to. Should means whatever should means. And
so change the shall to should in the first bullet point. And instead of it is suggested.
Or those members should be selected from among.
Okay. Is anyone opposed to that? That sounds okay. Okay, very good. So then the next question, are we choosing to add cultural diversity in the three items that Rick mentioned in that third bullet?
Or eliminate gender.
Or eliminate gender, yes.
Because you're just adding one instead of others, you know. And that way you're really excluding.
Then we can go back to having a board of all white men. I mean, I don't think that's what we want, right?
I don't think so.
I like the idea of expanding instead of taking away. It shows that we are at least considering it and naming it as important.
It's
That's a
very-
great idea, Laura.
I agree.
I agree.
Okay. So what do we want it to say then? Gender, geographical, gender.
Culture and ethnicity.
Ethnicity, yeah.
So should it be general to say the committee should work to ensure there's diverse representation on the committee to include, and then list those to include, but not limited to, and then list a few? It's hard sometimes to just start listing them and then not include everything,
Yeah,
but still reach what we're trying to do, which is, like you said, a diverse board or committee.
I like that suggestion.
I like that as well. It gets risky starting to list, then we'll leave something out. And so, yeah.
Not limited to, yeah.
That there is diverse representation based on, and then we list some of those items that we mention. Not all are listed.
It sounds like we want to leave the ones that are here and add a few others, but we don't want to limit it just to those. So does that mean some are in favor too of adding cultural and whatever
Ethnicity.
word, ethnicity?
David Fight, can you maybe put that together in a bullet for us and maybe read what you have so far to help us out?
So how about, so public and private settings is sort of already covered in that other sentence that talks about should be among public and private practitioners and educators. So it seems a little duplicative to have it on that line because it's already covered above. So what about for that third bullet, have something that says, in reviewing nominations, the committee should work to ensure there is diverse representation, including but not limited to geographical, gender, culture, and ethnicity?
Yes, that's good.
That sounds good. Okay, I'm assuming no one is opposed. Didn't hear any opposition. Okay, looks like that's great. Thank you, David, for helping us out with that.
Let's see. The next item is item for board review and consideration number 5, the 2-year terms, 4-year maximum. So as I mentioned before, it talks about advisory committee members serving 2-year terms, and they can serve up to 4 of them, which would be an 8-year total. But as I mentioned before, some of those terms in the past just kind of ran together. So if it is 2-year terms, I'd like to formalize it a bit more and bring to the attention the chair of the board, the opportunity to reappoint members for a 2nd term or 3rd term or 4th term. But, you know, and going down this list, I wanted to highlight that 2-year term for you and the 4-year max or 4 terms maximum, and see if you wanted to continue with that or if you wanted to do something different.
I'm not necessarily opposed to the terms and how it's listed here. I think what we ran into is there's so many people that have overstayed their terms and extended those that I felt like we were not allowing other people to have the opportunity to be on advisory committees. So if we're going to say this is what we're choosing as a board to do, I think we need to follow that, and I think be better in the future about when those terms end, then we either offer at the limit of the term, I should say, of those 4 years, or those the 2 4-year terms, that we find others that would maybe want to be on the advisory committees. So I'm not opposed to this. It's just a comment.
I agree. I think there's some things that make sense about it. A lot of us board members do end up serving 8 years. So it kind of makes some sense. I have been keeping track of the terms for a long time, and I send out emails when their 2 years is up and say, you know, because it comes by really fast. Do you want to serve again? And, you know, the majority of people say yes, but sometimes it's an opportunity for somebody to say, no, I've got other stuff I got to do now. And so they can bow out gracefully. But also I published the list, and I'm started using the 8 years so that it's just in front of them. That's your out date. No matter how many times you say yes to me, you're done, you know, when this, and then that way, whoever takes my place on the board can have that list too.
So is this language approved? Is there anyone opposed to this language at all? All right. Sounds like that's great. David?
Okay. And those were the items that I had listed. I do want to circle back around to one item, because when I initially drafted the report, I guess I've had some additional thoughts since that point, and I mentioned it when I went through it all. But there is an item that talks about the code of conduct or conflicts of interest and compliance for board members. And I highlighted there that there were a number of shalls that I would recommend changing to should. And then one of those items at the end had to do with members of the BSRB not using the agency's name or agency information for personal gain. And then there was some, the original board governance policy referred to board members and staff. And so on that item, I did highlight it for the board. I didn't specifically say that I think the part about staff should be struck from that. So it's really more of a question for you, but I do think it would probably be helpful for, as it relates to staff members, maybe allowing the regulations for state employees to cover staff members instead of including something like that in a board governance policy. But I didn't want to just assume that that was the direction of the board without circling back to that one. So just wanted to bring it back to your attention and see what you felt about that item as it relates to staff members.
And these are items that I was thinking we were striking. So is that not what we're doing in that area? Because that's where we don't have any, I keep saying jurisdiction. I know that's not the proper word, but we don't have any ability to control that or have any say over those items.
Well, so when I initially put the recommendations together, or the items for potential changes, I changed a lot of the shalls to should.
Right.
So if you wanted to keep those, that would be the language. And I had language that changed the part of it referring to staff as shall, because the board does have authority over staff, at least in terms of the executive director. There's other statutes that say the executive director has authority over the hiring and firing of other employees. But as it relates to staff, if the board wanted to include that language restricting staff, I wanted to separate it out from what the expectations are of board members. But you know, in talking more with the director of governmental ethics, it just seems like something that maybe should be removed from a document that deals with the board versus something that could refer to other members of the staff. So I probably, in having further conversations on that point, I would probably recommend the part referring to staff is struck from a document like this, and just the existing statutes and regulations prohibiting state employees from accepting things would cover. But I didn't want to assume that. I wanted to bring it back to your attention to see what your will is as a board on that.
So we could remove staff. Is anyone having an issue with that? Okay. So it looks like that's fine to remove staff, and we'll leave the other items listed there for board members.
And as I mentioned, if the board should want a small presentation from the Director of Governmental Ethics, just to kind of get some additional training for board members on what those statutes and regulations are, I think that could be helpful. But it seems like, it might be helpful to be aware of what's already in statute and regulation instead of having this and then that elsewhere. So I will take the board's decisions today and I will clean it up, and then I'll try to have it ready for you at the next November meeting so you can see what a cleanup version would look like. And I will, instead of using the word governance, I'll try to think of another term that may be more in line with what other agencies are working on or already have in place.
Maybe expectations was a word I had thought, but yeah, that sounds great. Thank you. All right. I think we need to take at least a 5-minute break if everyone's okay with that, please. And come back in about 5 minutes. So.
What's the board members back? You can take a break.
Welcome to the Conference Nation conferencing service. Please enter your PIN number to join your conference. Please hold while we place you into your conference.
It's been about 5 minutes.
Do we need to wait just a little bit, David?
There are 2 board members who have not logged back on yet, but they're in the room, so.
Okay.
I think now there's just one, Andrea.
I see that.
Leslie, this is Jane. I just wanted, I had forgot earlier to point out, we had another BSRB meeting. It's still October and I'm wearing my pink. For those who remember Marilyn, I had, my CRC people heard this a couple weeks ago, but I had promised her on BSRB meetings in October, I would wear my pink.
Oh, how nice.
That's sweet.
That's very neat, Jane. I still miss her.
Me too.
Okay, Leslie, I think all board members have returned now.
Okay. So the next item is re-adding the language KSA 65-6306B to allow postgraduate supervised. That is part of your board packet.
Yeah, and I'll start this conversation. So earlier this year, the BSRB requested on behalf of the board the introduction of a bill, House Bill 2208, and also at the time there was a Senate version of that bill. And through the committee process, as sometimes happens, there are certain amendments that are put on the bill. And one of those amendments was a bill that, one of the amendments was something that struck some language as it relates to social workers. And in preparing for this next legislative session, we've had some internal conversations here in the office, and the bill was pretty extensive, and it changed a number of different statutes. And we had some conversations, and we were asking the question, is there anything that needs to be cleaned up from all the different changes? Is there something that maybe was modified that could potentially have unintended consequences based on all the different changes? And there was one part that we wanted to highlight for the board and for your consideration. And so I'll go ahead and share my screen. So let's see. Okay, and this has to do with KSA
656306.
Yes, and the part that I'll specifically talk to is, or Leslie too can help with this. This has to do with C, and this has, well, the part that was struck with the amendment was C. So there was a requirement before that had to do with the number of direct client contact hours for social workers. And as you might recall, the version that was recommended by the board would have decreased the hours from 350 hours to 200 hours. And then in committee, there was an amendment to go ahead and strike the number of hours of direct client contact. And so you see here, there's a line that goes through with not less than 350 hours of direct client contact. But that's not where the amendment ended. It also struck some additional language that followed there, or additional postgraduate supervised experience as determined by the board. And it's that language, or additional postgraduate supervised experience as determined by the board, that we wanted to bring to your attention as board members, because we wanted you to take a look at this language, and we don't want this to be any more restrictive than was discussed in committee. This change in terms of striking 350 hours was not a change that the BSRB had put forward, but all that was talked about in those committee meetings was they wanted to eliminate this 350 hour specific requirement in statute. The language about the postgraduate supervised experience really wasn't discussed. And Leslie, Alan, I'll go ahead and refer to you in terms of how this relates to other statutory provisions and why we wanted to bring it to you. So.
The problem with the new language is that it says a clinical practicum, and there are practicums that are not clinical. They're administrative, specifically administrative would be the most problematic. So in order for someone who had an administrative practicum to become an LSCSW, they'll have to go back to school and complete a new practicum, a new clinical practicum, along with all of the postgraduate supervised experience. So taking out the or additional postgraduate supervised experience is really limiting people. And we've had already a couple of people turn in training plans, and this has been a problem for them, and they're considering going back to get a second practicum at their university.
So in an effort to reflect what we think the will of the legislature was as this item was discussed, and we don't want it to be any more limiting. We don't want this to be unnecessarily limiting towards individuals seeking licensure. What we would recommend is that you consider adding back the language or additional postgraduate supervised experience as determined by the board. And we might have to play around with the language a little bit in working with the revisor of statutes, but that is our intention, is to not, we think when this amendment was made, it had a different consequence beyond just removing the 350 hour specific language. And so we want to bring this to your attention to let you know we're trying to clean this up. We're trying to reflect what both the maker of the amendment and the legislature was trying to put into place. But in terms of the interpretation, it just has created a little bit of a messy issue. We'd like to go ahead, and if we have a bill before the legislature, we'd like to bring this back to them in terms of trying to clean it up and reflect what everyone intended through the different amendments and their action.
Anyone have any comments or concerns with what they're proposing to us?
Seems reasonable.
Agreed.
Okay, as long as no one's opposed, then we'll go ahead and allow that change.
And we'll go ahead and we'll take some language and draft it up, and then we'll try to have it for you at the November 8th board meeting, so you can kind of see how the new language would reflect in statute. It wouldn't be the official write-up of the revisers, but it would be hopefully close to that. But we wanted to kind of highlight this item as we're trying to make sure there's no unintended consequences. And, you know, we don't believe this will be an issue that is, you know, any issue. We think it's going to be helping to make things more in line with what it was intended with the amendment. So.
Thank you. Next item on the agenda
sorry,
is
Leslie.
in residence as education requirements. Did I interrupt someone? Andrea?
Sorry, Leslie, I was just curious if Dave or Leslie, if anybody has reached out about those concerns, either from the university level or the NASW, just curious.
With the concerns that no, it's just been applicants who are going to have to do additional work that have raised concerns.
Okay, thank
The
you.
universities have.
Yeah, and we wanted to bring it to you as a board first, and kind of explain what we were looking for and why we had come up with this language for you. And now that we've talked about it at a board meeting, we can reach out to other entities and kind of collect some feedback on that. But we don't think there's anything that would be an issue with this. We think it's more of a cleanup type matter. So.
All right. Thank you. The in-residence educational requirements.
And this was something that at the last, or the first day of the planning meeting back on September 27th, the board has had discussions about should there be changes to any of the language concerning educational requirements as in residence for the different professions. And back earlier this spring, you know, as a board or as the agency, we collected feedback from different educational institutions. The advisory committees had discussions on this. And I understand that since the last meeting on September, some of the advisory committees have discussed this. I know there was a recommendation by the Marriage and Family Therapy Advisory Committee. And so we want to go ahead and kind of explain that to you, or just kind of highlight that for you. And if there were any other advisory committees that had any additional conversations on this, we want to allow the opportunity for the board to discuss it. Or if anyone else had further conversations they wanted to bring forward to the board on this, we wanted to allow the opportunity for that. So you want to talk about the marriage and family recommendation?
The marriage and family therapy, currently the regulation says that any program has to have at least half of the coursework completed in residence. And the Marriage and Family Therapy Committee would like to change their regulation to allow programs that are COAM FTE, Council on Accreditation for Marriage and Family Therapy Education. That any of those accredited programs would not have to meet the residency requirement. So it would bring it in line with professional counselors, that there's, you know, that their professional accrediting body has vetted these programs. So that's their request for a change. I guess I didn't add that the other programs would still have to have half the coursework in residence.
Leslie, would you repeat that last thing you said? I didn't quite hear you.
The other programs that were not COMFADI accredited would still have to have half of their coursework completed in residence.
Leslie, help me out. Is that where we're having the most difficulty though?
No.
Okay.
No, that's just something specific to MFT. The others already have, many of them already have that requirement.
So I think I got kind of hung up on different items here. So are you needing anything from us as far as the MFTs? Are we approving that?
I'll bring it back. I have to actually amend the language and then I'll bring it back for your approval.
Okay. All right. So I think that's the last thing. Is that all of the discussion on that? All right. Well, then the last thing is adjournment. So I guess if we have a motion, Bruce, don't get too excited. Bruce, do you have a motion? No, I can't say that. Is there a motion?
I move that we adjourn.
Second.
I will second that.
Thank you. All in favor, say aye.
Aye.
Is there anyone opposed? All right. Well, we will see you all next time. Thank you so much for your hard work, everyone.
Thank you.
Appreciate it.
Thank you.
Bye-bye.
Aye.